It is my pleasure to introduce our next speaker, Tony Fleming. For openness and transparency, just to let you know, Tony has been the Township of Elizabethtown-Kittley's lawyer for quite some time. The firm of Cunningham Swan was there when I came, which is 600 years ago. Tony started off his career in Toronto, working for private firms where he specialized in land use planning and environmental law. The city of Kingston was very, very lucky to recruit him many years ago. I'm making Tony older by the second. And that's where he honed his skill in municipal law as well. After that, he joined Cunningham Swan, and he has specialized in pure environmental and land use planning law as well as municipal law. The Law Society of Upper Canada has certified him as a specialist due to his experience. They also use him in numerous instances to speak on their programs. The Ministry of Municipal Affairs and the Ontario East Municipal Conference also relies on Tony as a speaker on a regular basis. I'd like you to join me in welcoming Tony. Thank you.
Well, thank you all for inviting me here, and congratulations to all the new and returning councillors. For those of you who are new, welcome to the world. You have a steep learning curve ahead of you. For those of you that are returning councillors, you knew better, so you have no one to blame but yourselves. And for the new ones, forget I said that. So what we're going to talk about today is a general orientation session. I have in the slides, if you have the hard copies, this is about a 2-hour presentation normally. So I have an hour, don't worry, it's only going to be an hour. I've given you all the slides because it's a good reference. If you have questions, you can always go back, and if you have questions beyond the slide, just give me a call. I'm happy to answer questions anytime. So there are some pieces of this that I will go through a little faster than others, just to make sure we stay within our time limits here. And at any time, if you have questions, just raise your hand. I'd like to get those questions as we go. I think that really adds value to this rather than trying to wait for the end or trying to catch me at the end. So the first few slides we'll go through fairly quickly. These are just straight out of the Municipal Act, just setting the table for what it is that you are going to be doing for the next 4 years. So purpose of municipal government, that's set out in the Act. If we could have the next slide. Then what we've done here, we have this slide and the next slide that just lists some of the legislation that's applicable to municipalities. I'm not going to read these pieces of legislation to you, but know that I could have made this a few more slides. Everything you do is regulated somehow. There is a statute, there's a regulation, there's a policy document. The things municipalities do have a lot of layers to it, and you don't need to be an expert in all of these things, but you need to know that they're out there, and you need to rely on your staff to tell you what the rules are. So we can have the next slide. Some of the powers, I think this is key because what you're doing is governing a municipality, obviously. You do that by bylaw. And your bylaws can regulate, they can make people do certain things, you can license certain things, and you can be generic in your bylaw, you can be specific in your bylaw. And the last line there says you can differentiate in any way and on any basis the municipality considers appropriate. It's just this side of discriminating, not on a human rights basis, but taking the view that different businesses, for example, need different regulations than other businesses. And you have that flexibility built into the Act. So that's important to appreciate when you're trying to figure out what's the best way to govern the municipality. Next slide. And under the Municipal Act, they have a few sections that deal with your powers. This is the natural person power. It just means in legalese that you can enter into contracts, you can sue, you can be sued, you can buy property, you can deal with your employees. Next slide. We also have the separation of powers between the upper tier and the lower tier. I'm not going to get into the details of that. You should have an understanding of the fact that there are different rules whether you're in a lower tier or an upper tier. Next slide. This just sets out some of the things that upper tier governments are specifically identified as doing within that scheme. And if you're within a single tier municipality, then you get the benefit of both upper and lower tier powers. Next one. Lower tier, this just sets out again the lower tier powers. These are things that should be pretty obvious to everybody in the room, so I won't spend any time on that. The next slide. This one I will spend a little time on because it's important to understand how you exercise power. The Municipal Act specifically says all municipalities' powers shall be exercised by bylaw. So what that means is you're going to have staff reports come in. The staff reports will have recommendations, and you will vote on those recommendations. Do you agree with them? Do you want to amend them and then vote on the amended recommendation? And what you'll find out is that not every staff report has a bylaw attached to it. And so if you read this part of the Municipal Act and you say, well, wait a minute. Everything has to be done by bylaw. How come the last 10 things we just did tonight had no bylaw attached to it? It's because administratively it would just be a huge burden to have separate bylaws for every single resolution that you're approving that night. So at the end of that meeting, you'll have what's called a confirmatory bylaw. And that bylaw will say, this bylaw confirms all the actions, resolutions, etc., passed by council tonight are hereby confirmed. And it's confirmed by that bylaw. Therefore, all the decisions you made have been made by bylaw. You just didn't separate each of them out with an individual bylaw. And so if you go to the next slide, you can also pass resolutions, and there are very few numbers of situations in the Act itself where resolutions are appropriate. And you can figure that out as you go along. But with a confirming bylaw, it really doesn't matter because you're going to cover off that eventuality at the end of that meeting anyway. The other thing you do is you follow procedure, and you will have certain policies that are known to you, the procedural bylaw being the first and obvious one. But the other thing to remember is that especially in the Planning Act world, there are certain processes that must be followed because those are mandated by the Act, and there are certain processes that have to be followed before a decision, and there are certain processes that are mandated after the decision. And we don't need to get into all of that. It would take far too long. But your staff will help guide you through what's necessary in terms of pre versus post process. Next slide. And so the distinction, the way I look at it when you're thinking about a bylaw versus a resolution, it's never wrong to have a bylaw for every decision. It's just burdensome. It's cumbersome. It's not something you actually need with the confirmatory bylaw. But there will be certain decisions that you want to have a specific bylaw. So the way I think about this is if there is a lot of regulation that's contained in what you're doing, then it should be in a special bylaw. The obvious ones, a zoning bylaw, property standards bylaw, your animal control bylaw. That way the public know what the rules are, and you can give to the public those bylaws. You can post them on your internet site, you can hand them out at the front desk, or so on. And those are the ones that I recommend you do have a specific bylaw for, because it just makes regulating easier. It makes it easier for the public to understand what they need to do. Every bylaw has to be in writing, every bylaw has to be signed by the mayor and the clerk, and every bylaw has to be under seal. Until that is done, the bylaw is not actually in effect. So those technicalities get wrapped up at the end of that council meeting when the bylaw is now in full force and effect. Next slide. Excuse me. And so if we're looking at those were the bylaws, when can we do just a resolution? You do resolutions when it's an administrative matter, when it's something you're just agreeing to, but there's no need to have the formality of a bylaw. Next slide. And of course, after you have a decision, somebody's going to be unhappy with it. Doesn't matter what the decision is, somebody's always unhappy. And those decisions that you are making are subject to challenge, and they're challengeable in different ways. You can have an application to court by a citizen who feels you've exceeded your legal authority, you've done something in bad faith, or you haven't followed some necessary pre-process in advance. Some decisions, the Planning Act decisions, for example, are going to be appealable to what used to be the OMB and is now called the LPAT, or the Local Planning Appeal Tribunal. And then there are some things that can't be challenged. The general rule that's established in the Municipal Act is no one can challenge your bylaw solely on the basis that it's unreasonable. So you get to make decisions that people don't like, and the simple fact that they don't like the decision isn't in and of itself a reason to challenge it. They need to find something else, that you were acting in bad faith, or that the decision you made you didn't have jurisdiction to make, something like that. Next slide. Some things you can do to remedy your bylaws. You can issue orders to comply, work orders, remedial action. A good way to give you an example is a property standards matter. So I come from Kingston, so in the Queens area we often have couches on the front lawn that people are using or not using for months at a time. Those often get the neighbors a little excited. So you can issue a property standards order, remove your couch. If that couch is not removed in a timely fashion, sometimes that happens, then the city can go by with a big truck, throw the couch in the back of the truck, and the landlord gets a lovely invoice at the end of that process for the cost to remove and dispose of that couch. The cost of doing that, in the case of property standards, can be put on the taxes, and you collect it in the same manner as taxes. You don't have that every time you do something, so you need to think through your remedy section before you start spending municipal money, because sometimes you can get it back, sometimes you can't. Sometimes you just have to bite the bullet and spend the money even if you can't get it back, but that's a decision that you'll make as a council. The other thing you can do, you can shut utilities off if you run a utility. You can sell property for tax arrears, you can prosecute people, and you can do a civil action. So you can send me to court and we can seek an order of the court. And it's beyond the scope of this discussion, but when we're dealing with enforcement, there is always a question. Do I prosecute? Do I go to Superior Court and get an order? It depends on what your goal is. Is it trying to deter other people? Is it trying to get a certain thing corrected? Yes. In your bylaw, it will establish who is the staff person or who has the authority to issue those orders. So for example, under a property standards order, it will probably identify your bylaw enforcement folks. Generally, those are the people who have the authority to issue those orders, but it can be specified in your bylaw. Under the Planning Act? The Planning Act is dealt with either through prosecution or orders through court. The chief building official would issue orders under the Building Code Act. Yeah, so your building official would have the authority to go in. They have specific statutory authority. They can issue orders to comply. They can issue stop work orders. They can issue unsafe orders, which means don't go in, this is an unsafe building, that sort of thing. And then depending on the severity of sort of the structural integrity or lack thereof, they can also order a demolition order. It just depends on the process. What you have the authority to do is to treat classes of people in different ways. So and that's a good distinction. I'm not saying you can say, Jane, you can't do this and I'm passing a bylaw just for you. What you can do is say, I don't like that Jane always has a couch in her front yard. I'm going to pass a property standards bylaw that says no one can have couches on their front yard anymore. I can't single Jane out. But if Jane just so happens to be the reason I pass the bylaw, that's not a problem. But the bylaw needs to apply to everybody who has a front yard with a couch in it. Does that answer the question? Do you mean one situation or one bylaw? Okay. Correct. That's right. Yeah, so long as you are treating everybody the same and not focusing only on Jane, then you have a legal bylaw. If you just have the Jane couch bylaw, that's a problem. And I'm sure Jane would move the couch if you asked her nicely. So we can have the next slide. So now we'll get into the roles of council, staff, etc. Again, these are all right out of the Municipal Act, so I'm not going to read through this. This just helps you understand in a very high level, generic fashion what the role of council is established to be by the province. We can have the next slide. They also have two particular sections that speak to the head of council, and the first bullet is the one that I get the most questions about. It says that the head of council acts as the chief executive officer of the municipality. I want to be very clear. You are not the chief executive officer. There is no such position in municipalities. It says you act as the chief executive officer. That's the generic sort of role or responsibility that you are exercising, but you do not have authority over staff, the hiring, the firing, etc. You are one member of council, and you vote as one member of council, and the majority rules. The rest of the bullets that are on this slide really help define what the province intended by saying you're acting as the chief executive officer. You have that leadership role, the trying to come to consensus role, herding cats, however you want to put it. Trying to decide, with council, what are our priorities? How are we going to move through the next 4 years? What processes are we looking to implement? What process are we looking to amend? Is our OP acceptable to us? Is there something that we want to accomplish as a council? And the role of the mayor or the reeve is to try and give that direction and help council move forward in that way. Next slide. Administration, obviously your staff, your CAO or your clerk administrator, whatever you call them, they implement council's policy direction. And it's important to remember while you're dealing with staff, your staff have to follow the rules as well. So it's not appropriate for you to say to staff, well, in this case, I'd like you to just, bend that particular rule or get around this rule because I really like this to happen. Staff are in a unique position of taking your direction, but also having a lot of rules and regulations that they just can't get around, that they have to follow. So it's important just to remember that dynamic. And the other thing that I'd like to say here, and just in terms of staff and council, is it's important for both staff and council to appreciate each other's roles. One councillor, I was doing this 3 days ago, expressed it as a partnership. But it's a partnership that is not necessarily equal, because you, as council, set the direction and the policy, and staff implement that. And so what you need to recall is that you can't, I call it getting in the kitchen. You need to stay out of the kitchen as a council. Your role is to set the policy. Your role is not to go behind the scenes and direct staff and tell them how to do their jobs. You tell them what their job is, you tell them what the result that you'd like to see is, and then you need to trust that they're going to do the work, figure out how to do the work, and as needed, come back to you for direction or instruction. Next slide. Chief Administrative Officer, again, this is set out in the Act. I don't need to deal with that in any detail. The role of the clerk, you must have a clerk. This is one of those roles that is mandatory under the Act. So if your clerk is leaving, you need to make some accommodation to get someone to be there, because every meeting must have a clerk. I don't have a slide for treasurer, but you also must have a treasurer. Those are the two statutory roles set out in the Municipal Act that must be fulfilled. Your CAO is not a mandatory role. It's a discretionary role, but these two are mandatory. Next slide. Chief Building Official, also a mandatory role, but obviously under the Building Code, not the Municipal Act. The Chief Building Official is a bit of a different cat, because you must appoint a CBO, But then the CBO is responsible by statute for enforcing and implementing the building code. That you should not expect your CBO to be coming to council to say, should I issue this permit, should I revoke this permit? That is not your role. You must hire and trust your CBO that they are going to do what they need to do under the Act. You can absolutely set policies for what you expect the CBO to do in his or her role. That's absolutely appropriate for council, but it's also inappropriate for council to get into the kitchen with the CBO and tell he or she how to do that job. There's a lot of liability associated with the building code, and you do not want to take that on as a council. That's why you have a CBO. Next slide. This is something we've talked about already, council staff relations. And I put a couple of examples on the bottom, and I think this helps understand, or helps you understand rather, why it's important to stay out of the kitchen. So, when the snow flies, and it will, you're going to get calls from people that their road hasn't been plowed. I can guarantee it. And when you get those calls, you ought not to be calling Public Works to tell them you must plow this road because somebody called me. I know you want to help people. That's why you're all here. That's why you spent the time campaigning to get elected. But what you have to appreciate is the municipality is governed by what's called the minimum maintenance standards, which is a regulation, and it categorizes all of your roads and sets, oddly enough, minimum maintenance standards for each of those roads. And as part of that, there's a timing function. You know, with so much snow and so much time, this road has to get plowed because it has this much traffic. You don't get to decide which road bumps up in that hierarchy. That's already been done by policy. You have that in place. So if you make that call, and if your public works person deviates from the plan, one of the things I can guarantee you is somebody's going to have an accident on the road that didn't get plowed. And then when you come to me and we start going through it, what I'm going to say to you is, why didn't you follow your policy? You now don't have a defense to the lawsuit that's going to come because somebody can't walk anymore. This is really critical stuff. You have to trust your staff that it's going to get done. I'm not saying the complaint is wrong. I'm not saying the road didn't or did get plowed and whatever. There's a process in place, and we'll talk about process a little later. The important point is that there's a reason, a really good reason why you don't try and get around this kind of policy and go behind and talk to staff. The other important thing is you've given staff, and let's move out of snow plowing, let's talk about some other projects. You give your CAO, clerk administrator, projects to do. The CAO then distributes that work amongst staff. Now, you as a counselor think, oh, I'd like to get this done. Somebody just called. Somebody sent me an email. You bypass the CAO. You go right to staff, and you say, I want you to do this. You've just put staff in a really awkward spot because it's pretty obvious that you're on council, and they may consider you their boss, even though you aren't, and they might do what you ask them to do. And now, when Mr. Brown says, why didn't you do what I asked you to do, what do you think they're going to say? They don't have a good answer. I know I was supposed to do that, Andy, sorry, but Councillor X told me to do something else. They don't have the position that you do. They don't necessarily have the ability to say no. So you ought not to be putting them in that position. Next slide. And then we have some liability, obviously. Whatever you do, somebody can sue you for it at some point. There are some defenses that are in effect in the Municipal Act. I'm not going to go through those because I think there's some more important stuff that we need to deal with. So we'll just slide through the next slide. The Safe Drinking Water Act I will mention just because it does have a personal impact on the councillor as an individual. If you have a drinking water system, you can be held as a councillor personally responsible for fines under the Safe Drinking Water Act. If you don't have a formal, like sort of an urban style drinking water system, you may not be out of the woods yet either, because there's something called non-residential small municipal drinking water systems. If this hall wasn't on municipal piped water, it would be on a well and septic. That is subject to the Safe Drinking Water Act. So if you have small community halls that are on wells, you have potential liability as an individual under this act. How you deal with that is to make sure you're getting regular reports from your staff about how they're complying with the act, and the act builds in some defenses for you. If you're relying on advice from a lawyer, an accountant, an engineer, that's a good defense under the act. The important piece to remember is make sure you're getting the advice and the reports from your staff, and if something doesn't make sense, question them. That's how you exercise your due diligence. Next slide. This is also an important slide for your personal liability. You don't have personal liability for most things you do as a counselor. And I say most because the immunity is lost if you're acting in bad faith or if you're acting outside the scope of your duties as a counselor. And those are very broad concepts. Bad faith is one of those things that the court knows it when it sees it. You know, you're just acting in a way that if you'd actually thought about it, you know you shouldn't have done that. Just act with respect for the process, inside the scope of your duty, and you shouldn't have any problem. Next slide. Oh, sure. Council has the ability to indemnify. They don't have an obligation to indemnify. So you'd have to check to see if you have an indemnity bylaw in your municipality. Because there certainly are indemnity bylaws out there. I know with certain municipalities they do have them. And it's just a question of if you have one or not. And again, most of those bylaws are drafted, especially if I drafted them, that say, provided you are acting within the scope of your duties and we're acting in good faith. So council meetings, obviously, you're going to be having them. You have a procedural bylaw. That's important for figuring out how the meeting is run, what the schedule of things are, that sort of thing. We're not going to talk about that in any detail. The last couple bullets about quorum, the whole issue is, what's a meeting? If a quorum of council gets together to talk about council business and materially advances that discussion or decision making, that's a meeting. So today, we're having a whole bunch of council meetings, but you passed resolutions that it's a training session, and we're not really advancing the decision making. So let me back that up. There's two ways we could have this meeting. One, you each pass a resolution that we're going to have this training session. That's an exemption in the act. Or, so long as we don't materially discuss or advance the decision-making, specific decision-making of your councils, it's not a meeting. So the question I get every time, well, can we go out to the bar and have a beer? Sure you can. Just don't talk about council business. Now, what else do you folks have in common? I don't know, but that's not my problem at this particular time. All I can tell you is don't materially advance the discussion or the decision making. And if it's too hard to do it, finish your beer and walk away. That's all you can do. The problem is that every meeting must be held in public. And you must tell the public in advance that you're having a meeting, when you're having it, and what generally you're going to talk about. So have the next slide, please. So, oh, sure. Before inauguration, you folks who are newbies aren't members of council. You can do whatever you want. The act doesn't apply to you. Until you, don't get too excited. There's going to be trouble at that table. I can feel it. If you have not taken the oath of office, this doesn't apply to you. So if you want to get together as new councilors and talk about what you'd like to do, nobody can stop you. If a quorum of councilors gets together, then there's a problem. But the new folks, until December 3rd, fill your boots. Now, what is important to remember is that you don't carry that carefree attitude into after December 3rd. And at the end of the day, most of this isn't a problem. There is closed meeting investigation provisions. You might get one of those. But for the most part, I find that most councils do a good job of this. Where people fall down is emails. Because if you have a chain of emails and every member of council's on that email, you're already dangerously close to a meeting. Provided those emails do not materially advance the decision making, there's an argument that you haven't had an improper meeting. But if you're going back and forth on emails and everybody's being copied and you're saying, yeah, I'd like to do this, no, let's do this instead, you're trying to advance the decision making of council. You're doing it outside of the public's view. That is an illegal meeting. And if you have an illegal meeting, even if you then go into open session and have a debate and vote, someone could challenge that decision and invalidate the bylaw. Notwithstanding that you passed the actual bylaw in open session, if you've done things you ought not to have done getting into it, they can still challenge you. And this slide speaks to something that's new in the new amendments to the Act. Now council can pass a bylaw to have electronic participation or telephone participation in a meeting. There's a couple of rules. You can never do it in closed session for obvious reasons. And within the bylaw, you can impose some restrictions. But so long as you have an in-person meeting with quorum, live bodies sitting in the chair of quorum, you can have councillors phone in and participate in that meeting. The Act is silent as to whether or not they can vote. So my view is, in your bylaw, you can have councillors vote by phone. If you could also, in your bylaw, say councillors can't vote by phone. It's up to you. I don't know why you wouldn't have them vote if they're participating. If for whatever reason you don't want a councillor to vote by phone, you need to be aware that if you have a recorded vote that's called, and you've said to this councillor you can't vote because you're calling it in, that councillor's vote counts as a no. Because an abstention at a called or a recorded vote is deemed to be a no. So you have a procedural wrinkle there, so you just need to be aware of that. The best thing to do on all of this in terms of trying to figure out what does materially advance the decision making mean, just don't do it. I mean, you don't want to be all sitting at the bar 2 or 3 beers in and go, well, what does this really mean? Are we materially advancing the decision making of council? It's probably too late at that point. Just don't go down that road. It's the easiest way to figure this stuff out. The next slide, please. Closed session. So the general rule, all meetings in public. Easy. There are a number of exceptions where you can have meetings without the public present. I'm not going to read through the list. Can we have the next slide? The list goes on, training at the second last slide. And then the next slide, these are new. So this just came in a year or 2 ago. They've broadened the categories of things that you can go in closed session for. And the last bullet is the most interesting for me because this, I think, gives you some really nice flexibility. So you can talk about a position, a plan, procedure, criteria, or instruction to be applied to any negotiations carried on or to be carried on. So, doesn't have to be about buying or selling property, which is another exemption. It can be about any sort of negotiation you have. This is important for you to consider because there are certain things that are best done outside the public's view because at the end of the day, what your goal is always to do what's in the best interests of the public. So I understand that the Act is premised on transparency and so on, but the Act also gives you this ability. So in certain circumstances, the province recognizes that it is more beneficial to the public interest that you be able to talk about certain things without worrying about how the public is going to react or talk about what you've said or didn't say. Have that free-flowing discussion. But more importantly, you're not tipping your hand in terms of, well, we would like to do some sort of a program. And in that program, you want to discuss the program, figure out what's the right way to do it. Maybe it has a component of you'll need to buy some land. You're not talking about buying land, so you couldn't use that to go in camera to talk about the big project. But if it turns out as part of that discussion that there's only one parcel of land in your municipality that would allow this project to go ahead, guess what happened to the price of that parcel? That's why it's important to be able to do some of this in closed session. The next question you're going to ask is, well, do we have to do it? No. You never are obliged to go into closed session except for very limited exceptions. If you're talking about MFIPA, you need to be in closed session because you don't want to breach MFIPA, talking about whether or not or how you're going to comply with MFIPA. And for labor relations purposes and identifying persons, you don't want to do that in open session because that, again, can breach your obligations of confidentiality. The other one that's not mandatory, but I'm going to put it in my mandatory category, is getting legal advice. On very rare occasions, I will give legal advice in open session. There's usually a political reason why I'm being asked to do that, but I always say it's a bad idea. And it's a bad idea because I give you my advice whether I'm in open session or not, and you may not like my advice. It's better to hear the bad news from me in closed session, and then we can manage the bad news. I'm not saying it never becomes a public matter. I mean, you can't, as we'll find out, you can't vote in closed session. So at some point you're going to have to go out, but we can have those discussions openly, and I don't have to worry about watching what I say so that I'm not putting you in a bad position. Because if I'm not giving you all the information because I can't give you the information, or doing so would prejudice the municipality, you don't know what you don't know, and you're now making a decision with incomplete information. And there's also something called waiving privilege, which means all of my work and opinions might be opened up depending on how I say what I say in open. So it's just something we don't want to do. So we could turn the page. You can, as I said, make a decision in closed session, but only in very limited circumstances. 2 reasons why you can vote in closed session: to give direction or instructions to staff or consultants, or to make a procedural decision. So the procedural is the easy one. We'll do that first. If you're in closed session, you obviously need to vote to get out of closed session. They can't trap you in there. You need to be able to make that procedural decision. There are other procedural decisions that you can make in there, and so long as you're not making a substantive decision, that's okay. You can also give instructions to staff, and this is where it gets a little murky. Because I'm going to tell you right now, you can't give staff instructions unless you've made some kind of substantive decision, because otherwise, what are you directing them to do? So the line there is blurry, but the province has specifically given you this ability. And so it really is a case-by-case assessment, and I do this for all of my municipal clients about how far can you go. And at the end of the day, there are techniques I use to make sure you're making a legal decision in the right way. This is probably not enough time to talk our way through that, but just to know those are the general rules that you have to follow. Next slide. And it's important because if you have an illegal closed meeting or have an illegal vote in closed session, even if you then go out into open session and have the same vote, anybody can challenge that vote, and that bylaw will be determined to be illegal and of no force and effect. Next slide. Accountability, transparency. There are a number of policies that you will already have in your municipality. The 3 that are in bold are new policies that you have to have in March of next year. You'll have to have a council staff relations policy. This is always funny for me. How are you going to protect and enhance the tree canopy and natural vegetation in your municipality? So obviously this came out of Toronto. I can't say it's critical that Westport preserve every single tree in the village, but you actually have to think about it and pass some kind of policy. So I'm sorry. The last one makes 100% sense. I don't know why it hasn't been in before. Pregnancy and parental leaves for counselors. Your staff have that ability, but if you miss more than 3 months, you can have your seat declared vacant. So obviously this is a good policy for council to have. Next slide. So we're talking about decorum and conduct. There's a few things that are obvious. Procedural bylaw, code of conduct, Occupational Health and Safety Act, workplace violence sections of that act are important. Next slide. Which gets us into the code of conduct. This obviously will be in full force and effect in March of next year. I won't spend too much time on this one because there is some other things that I think are important to deal with. Just know that if you have a code, read the code, understand the code. If you don't understand something, get somebody to help you out. As of March, your integrity commissioner will be able to give you advice and recommendations and opinions as you go along. That, to my mind, is one of the best things that this particular requirement contained. Now you have the ability to seek advice before you do something you shouldn't. Take advantage of it. It doesn't have to take a long time. It doesn't have to cost your municipality a lot of money. But for you as a counselor, it's so important not to make that misstep. Especially, Municipal Conflict of Interest Act matters. As we'll see, that has really serious consequences. So take advantage of that. Make sure you know what you're doing. Next slide. There are 4 things your code will need to contain. These are the only 4 things that are mandatory. Gifts, respectful conduct, confidential information, and use of municipal property. You could legally have a code that only does those 4 things. I'll tell you what I told the people in Carleton Place on Wednesday this week. You can do that, but the public already expects so much more of you people. That to not have a more fulsome code, you're asking for trouble. And the other thing a code does for you, it gives you the ability to say to someone who challenges you for something you've done, wait a minute, look at my code of conduct. This is what it says, this is what I did, and if you've asked questions or asked for an opinion from your IC, you can say, and I asked my integrity commissioner, and he or she said what I did was fine. You now have a fantastic answer if somebody comes at you on one of these things. That, to me, is the real benefit of the code of conduct. And as I said, you're already scrutinized for most of whatever's going to be in your code anyway. You might as well get in front of it. Next slide. We just talked about advice and opinions. I don't think I need to talk more about that. Next slide. This I will talk about in a little more detail because this is something that you're going to have to deal with as an individual. So this isn't a council decision. This is an individual counselor obligation. You must comply with this act. Members of council can't comply for you. Members of council may tell you you have a conflict and suggest strongly that you do declare, but whether you do or not is up to you. And the chips will fall as they will. So if you don't, there are a number of penalties, the most significant of which is obviously your seat could be declared vacant, and a court could order that you not be allowed to stand for election in the next term. So this is significant stuff. Next slide. Conflicts are all about money. It's called a pecuniary interest, but pecuniary is not defined in the Act. Why? I don't know. Can you make a nickel or lose a nickel? That's the question. Now, as we'll see in the exceptions, if it's just a nickel, there's an exemption for that. But if you think about it that way first, it helps ground yourself and it helps frame the discussion. Can I make any money because of the vote I'm about to give? Can I lose any money? And if it's an indirect pecuniary interest, the effect is the same. An indirect is defined as if your parent, spouse, same-sex partner, or your child has an interest, or your employer, your business partner, if you're a private shareholder in a corporation, or if you're a majority shareholder in a public corporation that's traded on the stock exchange, the interest of those businesses or individuals become your interest. So, if your spouse has a pecuniary interest in something you're about to vote on, you also have that same pecuniary interest. So you need to think about this stuff before you get to council, because you need to really understand this. And come March, this is one of those things that you'll be able to ask the Integrity Commissioner about. So when you get the agenda and you go, I don't know if I do have a pecuniary interest here, ask the question. Because your obligation, if we could turn to the next slide, is to first of all identify it so that you can do the list of things here. Before any consideration of the matter at council, you need to declare. And for the new councilors, when you have your first council meeting, one of the very first questions after welcome and adopt the agenda is, does anyone have a declaration of pecuniary interest? If you have an interest, you must declare it. Now it must be in writing, and the municipality will keep a record of those declarations. And you must say what the general nature of your interest is. I, Councillor X, have a pecuniary interest in matter whatever on the agenda because my spouse works for whomever, and that is going to be discussed. Once you declare, you cannot participate in the discussion. As much as you want to, you can't. You can't vote, and before, during, or after the vote, you can't try to influence other members of council in how they will vote. You can stay at the council table in open session. Some people actually physically remove themselves. There's nothing wrong with that, but it's not an obligatory member or provision of the act. In camera, different story. You cannot be present for that discussion and vote, well, for a procedural matter or for directing staff in closed session. You have to leave the room, and for obvious reasons. And the new amendments have changed this slightly, and this is mostly because of Rob Ford. If you have been found to have breached the code of conduct and council is discussing amongst itself a penalty, you can be present for the discussion of the penalty, and you can provide your input to council on the issue of penalty, not on whether or not the breach occurred. That discussion happens without you. Once council determines there is a breach and they're talking penalty phase, then you can come in and have your time before council to say it shouldn't be 3 months remuneration that you take away, it was inadvertent, whatever you want to talk about. That's new. Next slide. There are a number of exceptions that are important, and one of the ones I just mentioned earlier, the nickel. If it's such a small amount or the interest is so trivial or inconsequential, there's an exemption. And really what this act is all about is giving the public a sense that what you're doing is being done with integrity, that you're not biased, you're not influenced by someone or some financial interest. So if it's so small an amount that no reasonable person could consider that you would be influenced by it, that's an exception. It's an honorarium or so on, that's an exception. One of the ones that's important is if you have an interest in common with the electorate generally, that's not a pecuniary interest. The easy way to figure this one out is all of you will vote on budget. Budget includes property taxes. You all are affected by property taxes. So you have a pecuniary interest in that budget discussion. But obviously I can't conflict all of you out because who would vote on my budget? So that's not a conflict. There will be other issues that will be sort of a general nature that's affecting everybody. Utility rates, or if there are road improvements that are necessary. Well, you all have houses in the municipality that are on roads, so you all have an interest in those roads, but it's in common with everybody who lives on all of the roads, so that can be an exception as well. The next slide. One of the criticisms of the act before these amendments was that the removal from your seat was the only penalty available. And the courts criticized it. There was a judicial inquiry into Hazel McCallion in Mississauga. Justice Cunningham criticized the process because the criticism is, well, we don't have anything except the most severe sanction available to us. And the act was drafted such that if the court found a breach, they had no discretion. They must declare the seat vacant. So what happened is you're going to see a lot of decisions talking about whether it was inadvertent or otherwise inconsequential, because that was the only provision in the act that let the court not remove the counselor from their seat. So you get a lot of, in my view, terrible decisions only because the court didn't want to pull the counselor out of their seat. Now we have additional penalties, so hopefully that discussion gets a little more based towards common sense. So now you can reprimand a counselor or you can suspend their remuneration up to 90 days. Same penalties that are available for code of conduct. And if it's egregious enough, they still have the ability to pull that counselor from their seat. Next slide. We're getting close to running out of time here, so I'm just going to... All right, we've got two things left. One is planning and one is MFIPA, so I'll try and split those up equally if I can. The general rule in MFIPA, everyone has access to municipal records. And there are a number of exemptions that we can talk about, and we'll talk about it pretty quickly because the rule is pretty broad. The next slide should have the exemptions. I won't go through the specifics, but what will happen is if in your municipality you've designated what's called a head for purposes of MFIPA, that person has to decide, first of all, is this request frivolous and vexatious, which is one of my favorite questions. If it isn't, then what are our records? And once I get the stack, I go through them all. And the head will look at every single one to say, is it or is it not disclosable? And the exceptions we'll talk about in this list, draft bylaws, advice or recommendations, information received in confidence. We can turn the slide to the next one. Trade secrets, all this sort of thing. The important one is the last bullet on the list, personal information. That's the one that your head of MFIP is going to spend most time on probably. Because this is trying to figure out how to balance the general proposition that all of these records should be disclosed with the requirement that we need to protect personal, private information. And a lot of times the way you do that is redacting. You get the Sharpie out and you just start stroking material out. Names that could identify them, addresses, emails, phone numbers, that sort of thing. And that's a process that your staff will go through. If council hasn't designated a head, council is deemed to be the head under MFIPA. Sadly, this will then come back to you folks at the council table in a closed session because that's an exception to the open session rule. And you'll have the enviable task of going through pages and pages and pages and trying to figure this stuff out. I suspect most of you have delegated that because council should not be doing this. This is too much time. I have staff right now in certain municipalities. One request alone took staff 4 days. Not doing anything else. 4 days. Just before the election. Happy, happy staff. So these things can really suck the life out of your staff. And you can't do anything about it. You have to follow the act. People are entitled to these records. But more importantly, you need to go through them all and make sure you're not disclosing records that are containing personal information, because that's a breach of the act. So there's no shortcut to this stuff. It's not like you can say, okay, I found them all, forget it, we'll just send them out, who cares? Well, the people whose personal information is contained in there will care, and that's a breach of the act. Next slide, please. This is just a general slide about how to deal with it. Yes, at the back. You can. So the regulation provides they have a certain hourly rate and a per page photocopy rate and things like that. And if I think it's $100. If it's going to cost more than $100, you give the requester an estimate of costs and they need to cut you a check for 50% of those costs. So if we're talking about thousands of pages and hours of staff time, you can get some of that cost back. And sometimes when you send out that note saying, here's how much it's going to cost, they just go away. Or they appeal you to the IPC, or the Information Privacy Commission, and then they argue about whether your costs are reasonable. So it's just a never-ending battle. And then when you do disclose, they can still appeal that decision to the Information Privacy Commissioner that you haven't disclosed enough, or you redacted too much, or I know there's other documents and you're not giving them to me. And that's, again, another process. So it can drag itself on, but hopefully your staff will deal with this and they'll get advice as needed to make sure you're complying with the act, because that's really the key here. We can do the next slide. What's important for you folks is that you, as a council member, have no greater right of access to the records of the municipality than anyone else in your municipality. So if you just walk in day after my oath of office and say, I want to see it all, no, you can't see it all. You can make an MFIPA request like anybody else, but you don't have any special access to these records because, remember, it is the corporation that has the obligation to maintain privacy where privacy should be maintained, and you can't short-circuit that process. But what you can do as a councillor is if something is in front of council and you need information to make a decision, that information is not something you need to go through MFIPA for. But it has to be a matter that's actually in front of council that you need the information for. Next slide. Yes.
Can you just comment, please, if you're using your personal email to conduct village or municipal business, does that become a record that's disclosed?
Yes. There are very, very limited exceptions to the personal email rule. And the IPC is a bit all over the map on this one, so I can't give you hard and fast, but generally speaking, if it was something like ward business that was just between you and a member of the ward, maybe you could protect that. But even that, I think in many circumstances, the IPC would make you give it up. And so what will happen when staff get this request, you as a councillor may get a request saying, give me all your emails about this particular issue. And it's a whole issue of control. When staff have tried to say in previous decisions, well, that's the councillor's email, it's not a municipal record, I don't control it. And the IPC says the purpose of this act is to disclose this stuff. And if you can hide those discussions by just having a Gmail account, what have I accomplished? Give it up. So, yes? If a request is made and the request relates to a third party, so not the municipality itself, the Act says that the person whose information is potentially to be disclosed is to be notified of the potential disclosure. So staff will come to you and say, we've had a request. They won't tell you who made the request, but the request is for whatever. And we've identified that you may have emails that are subject to that request. First of all, we need your emails. And then second of all, do you consent to them being disclosed? And then you, as an individual, can say, I object to the disclosure of this on whatever grounds you can look through the Act and come up with. So if there's something that, personal information, for example, if in the email you disclose your personal cell phone, strike that out. I don't want that disclosed. That's an easy example. To get into it in more detail, we'd really need to have a fact scenario, but you do have the right to be asked if you consent. And then you submit to the municipality what you are consenting to, what you're not consenting to. The municipality takes that and then makes a decision as to what is or is not disclosable. So land use planning. We've got a couple of minutes and there's literally no way I can tell you what you need to know about land use planning in 2 minutes. I need 2 hours, 2 days, 2 weeks. I don't know. It's taken me a lifetime to figure this stuff out. And then the province changed everything on me, and I don't know what the heck is going on now. The new rules are, to say the least, interesting. How do I say this? I don't like them because it's confusing. We've taken an apolitical process and we've made it political. So if you are making decisions, you have far more control now than the council you're replacing, because this system is geared towards protecting the decisions of council. So what I'm going to say to you folks right now is take that responsibility seriously. Avoid the temptation to make political land use planning decisions. It shouldn't be about the individual. It has to be about what's in the interest of the community. And you need to respect your own planning documents. So you have the Planning Act, which sits on top of everything. You have the provincial policy statement, which comes from the province and says these are provincial interests. Every decision you make under the Planning Act must be consistent with the PPS. Then you have your official plan, or the county's OP, then your OP. Every decision you make must conform with the OP that is applicable. Then you have zoning, site plans, subdivisions, all those sorts of things that implement the decision or implement the policy. What the new rules do affects really official plans and zoning bylaws. The balance is the same. So subdivisions, consents, minor variances, site plans, those are all done the same way we've been doing them for decades in the province. But for an official plan or official plan amendment, zoning bylaw or zoning bylaw amendment, there's now a new set of rules for appeals. And it's a bit bizarre. If you refuse an official plan or zoning amendment, the person who wants to appeal can only appeal if the zoning, I'll just use zoning because it's easier than talking about both at the same time. If the zoning before the amendment that was proposed didn't conform with your official plan or was inconsistent with the provincial policy statement, and if what they propose as an amendment will conform and is consistent. If you don't meet both parts of that test, you will not be able to appeal. So let me tell you what that means in practical terms. You have a zoning for front yard setback, side yard setback, lot coverage. I'm going to say to you with 99.9% certainty, your setbacks have nothing to do with the provincial policy statement. The provincial policy statement protects aggregates, natural heritage, cultural heritage, prime farmland. Your setback has literally nothing to do with anything about that. So we're talking about OP. If it's in your zoning, how can it not conform with your official plan? It would have to be some old, weird zoning that you just didn't catch, and you passed a new OP, and this policy just, or this zoning just isn't consistent. For example, you have a zoning that says 15 meters from the water, your OP says 30. That zoning doesn't conform with your OP. In that case, you might be able to appeal a refusal of council. But if your OP says 30 and your zoning says 30, and they want to rezone it so it says 15, they can't meet the appeal test because your original zoning did conform. No appeal. Your decision is the final decision. That is a lot of power. It's no more the board's going to overturn your decision just because the board favors developers, which I don't believe, by the way. So what I'm saying to you is take that very seriously. Think about what is the right answer. Your staff reports are now going to get longer because now they have to speak to that test. They have to tell you, was the previous section conforming? Was it consistent? And the reason they need to speak to it is because now if there is an appeal, no evidence can be adduced at that hearing. There's no examination of witnesses. There's no cross-examination of witnesses. I get a grand total of 75 minutes to speak to it. I do zoning amendment hearings under the old system, 2-3 weeks. A dozen witnesses. I get 75 minutes, no witnesses. So what's in front of you is all that's in front of the board tribunal. So that makes it more important that your staff speak to those topics in their reports. If you don't like the reports that you're being given by the developers, get them peer reviewed. You need the best information. You also need that information to be in the record, so to speak, so that if there is an appeal, it all gets put in front of the tribunal, because you can't put it in after the fact. I'm used to getting decisions, appeals, and then I start trying to bring in more evidence to support the staff report, because staff aren't in the habit of bringing in outside consultants to help with all the nitty-gritty that I'm going to need at a hearing. I don't know how you manage that, quite frankly. It's going to be a challenge. The tribunal is struggling with its own rules right now. I have 2 separate motions coming up this month just on how the rules of the tribunal apply, whether they're consistent with their own act. It's a mess. It really is. It's very confusing stuff. The province was scrambling, the tribunal was scrambling, so the rules, some of them just don't make sense. But we're stuck with it, and that's what it is. You don't need to worry about that so much. You need to worry about, how am I going to make a good decision? What does your OP say? What is your planning consultant or your staff saying? Listen to those folks, because they're the ones who have expertise. And if you're going to turn it down, you need to think about the OP, the planning. Is this the right decision for our community? Because ultimately that should be the touchstone that you use. I'll worry about the procedural stuff. You just get the decision right the first time. And in 2 minutes, you now know everything you need to know about land use planning. Thank you very much.
On behalf of all of us here, thank you very much, Tony. And as always, I have learned something from you today. Every time he speaks or we have a private conversation, he drops these little gems, and I appreciate it very much.
We have one more short presentation before we get to that lunch that I can smell. Conservation authorities are intermunicipal environmental protection and advisory agencies that work with local municipalities, government agencies, special interest groups, and the general public to protect the natural resource of our watersheds. We're pleased today to have Angela Coleman, General Manager of the South Nation Conservation Authority, and Summer Casgrain Robertson, General Manager of the Rideau Valley Conservation Authority, to give you an overview of the great work that they do.
Oh, overall, I think really it's just a test in common sense, isn't it? To see who in the world would spend a lot of time talking and keep you fine group of people from your lunch. My name is Angela Coleman. I am the General Manager of the South Nation Conservation Authority. I've been working in the field of conservation for some time, and I've also worked in the areas of communications and law, as well as some municipal law and condominium law. And I have with me today Summer Casgrain Robertson, and Summer will introduce herself when she comes up. And she's with the Rideau Valley Conservation Authority. So we do the same position in 2 different conservation authorities in your area. So Big Tree, that's me. 2 little trees in the middle, that's Summer. And then we have our other colleague, Jeff Gray, who's with the Cataraqui. Basically, we've put a map in front of you so that you can have a look and see. So if your municipalities are within the yellow area, those are municipalities within the South Nation Conservation Authority. The light green area includes areas in the Rideau Valley Conservation Authority. And the purple is the Cataraqui Conservation Authority. Each of the municipalities, the conservation authorities, cover off a lot of different municipalities. So where I am is basically looking at the upper tiers of Leeds, Grenville, Prescott and Russell, Stormont, Dundas and Glengarry, as well as a big part of the city of Ottawa. So the image that you have in front of you today, and as you get more into the board appointments, which is the reason that we're really glad to have a little FaceTime today, you can see that we're all dealing with quite a few municipal bosses. Most of us have about 16 to 20 municipalities that we're responsible to keep happy and we're glad to do that. And I'm very fortunate in my watershed to keep up on the news. All I really have to do is grab a copy of the Prescott Journal, and I can see what Mayor Pat and what Mayor Malanka have to say about the goings on. And then I even, by time, get a chance to see what Mayor Todd is up to in Prescott. So basically today we're going to show you the areas of jurisdiction that we have, show you our current board membership, and it's like other local board and committee. And hopefully, if you are up for these appointments, to consider donating your time and services to the work of conservation and the work that we do. Next slide, please. Some of the things that we do, often you will be able to hear from us on a number of these projects. But at the end of the day, the people that you call when you have a problem usually is me in the yellow area, Summer in the green area, and Jeff, who's not here, in the purple area. So to put a face to a name, I think, is always helpful. We are called, it's a good segue from Tony's presentation. We deal a lot with floodplains and other areas of natural interest, wetlands, drainage issues, but we also have the pleasant task of providing other parks and recreation lands, as well as many programs and services that the residents of your watershed do enjoy and partake in. We give them grants, we're there to provide sound advice, and to go out sometimes when between neighbors from time to time people have disagreements about what might be the right course of action and what might be the wrong course of action. So we're really there as your mediators on all environmental issues, and particularly on those issues that touch people at the local level. So we are going to be here throughout the lunch, but you can see the list involves a number of things. You may have seen us before. You may know us from previous engagements related to water quality, other activities having to do with your municipal water and wastewater treatment systems. But we certainly have, both Summer and I, been involved in the Conservation Network for a number of years. We're also routine presenters at the Ontario East Conference, Good Roads, OGRA, you name it. So you'll see us around from time to time. And certainly the case with me from a long line of politicians, which makes me know that, in fact, I'm quite happy in the role that I do have. So you're in for a wonderful time, and it's important work that you're doing for your communities. And if you do have questions about the environmental side of that, you can always give us a call. Maybe we can help with that tree business that Tony spoke to earlier as well. And in fact, we are helping some municipalities with that in the South Nation watershed. Next slide, please. With that, I'm going to turn it over to Summer. We've put a slide together that shows our current board appointments. Now they're super uber tiny. We are going to stay for lunch, so if you have an interest, you can find us, and we'll be glad to let you know how the appointment process works for your respective municipalities, as well as to answer any general questions about the programs and services that we offer on your behalf. So from South Nation Conservation, thank you to Andy and everyone at the counties for the opportunity to discuss with you our programs and services, and I'm going to turn it over to Summer and not keep you from your lunch.
I have 2 slides and then it's lunchtime, so bear with me. Just a quick show of hands. Anybody in the room ever sat on a Conservation Authority board? Just a couple. All right. So hopefully today, between Angela and I, we pique your interest, and it's a role that you might consider in this term of council or a future term of council. So as Angela said, the slide shows the current board members for our 3 conservation authorities from Leeds and Grenville. And one of the main reasons we wanted to get on your agenda today was because very shortly, once you're sworn in as the new council, you'll be asked to make appointments to the Conservation Authority boards. So depending on which watershed or watersheds your municipality falls into, you may be making 1 or 2 appointments to our boards of directors. So members can be either members of council, or you can appoint a citizen. So some of you will discuss around your council tables who is best to send to fill the role on our board. Or you may post either on your website or in newspapers and solicit applications from residents in your municipality. So either is fine, and you can appoint a member to our board for up to 4 years. So you don't have to appoint them for the full 4 years, but that is the maximum term, and it's to line up with your term of municipal council. So last slide is just to give you a sense of what it means to sit on our boards of directors. So we have anywhere from 8, 9 to up to 11 or 12 meetings a year. We typically don't meet more often than monthly, and we take some months off. So it's a time commitment, certainly not to the extent that sitting on municipal council is. And we cover, obviously, the wide range of programs and services that Angela talked about. So in terms of role of a member, I would say right off the bat, attendance at meetings is important. Obviously, you're not expected to attend all of them, but the more meetings you're able to come to, you get a better sense of the cross-section of programs that we do provide in the watershed. Also important to understand the legislative and statutory responsibilities that we have. So Tony had a couple of slides that showed all the different acts that pertain to your municipality. Our list is certainly shorter, but it will become important as new board members to understand the Conservation Authorities Act, which is that overarching piece that we're governed by, but also other pieces of legislation like the Clean Water Act or the Building Code also apply to us. So certainly once our new boards come together in the new year, we start with orientation, similar to what you're participating in today, and we will walk you through those different roles and responsibilities. But at the end of the day, as a member of our board of directors, your key responsibility will be to understand what our mandate is and our purpose, and to certainly set direction and policy and strategic priorities for that conservation authority to achieve its vision and mission. So if it's something that you're interested in, I would encourage you to go on any of our websites. You'll find strategic plans, our vision and mission statements, you'll have annual reports. There's a lot of information that you'll be able to find that's a quick read that will give you a good feel for what it is that we're responsible for. And when you're sitting at our board table, I think it's important to remember that while you've been appointed by your member municipality, you are there to make decisions in the best interest of the Conservation Authority and the watershed as a whole. So I really enjoy the fact that we're governed by multiple municipalities around the table. These are big boards, so mine in particular is 22, but I will say it functions surprisingly well for such a large group, and it's nice to have the perspective of 18 different municipalities around that board table. But everybody comes with their own experience from their municipality. But at the end of the day, once the discussion and deliberations have happened, they make decisions that are in the collective best interests of that watershed as a whole. And that's really why conservation authorities exist. It's to break down those municipal barriers and to look at that ecological scale and that watershed scale and make good, strong, sustainable environmental decisions. So with that, we also have, of course, all of the good stuff we've talked about today, conflict of interest, code of conduct. We also had to do those this year, and they were due by the end of the year. So you'll also want to look at our administrative bylaws on our website. And it will tell you everything you need to know in terms of all of the procedural stuff and the rules that would govern you as a member. So if we have encouraged you or piqued your interest at all in sitting on a Conservation Authority board, then we would certainly invite you to express that interest at your council table or to pick a resident that will do a good job of representing you at our table. And as Angela said, if you have any questions, we're here through lunch. If not, we hope you'll join us around our table to create great watersheds in Eastern Ontario in Leeds County.